Today, let us discuss 20th October 2015 newspaper. A very well written article is by Justice Lodha about the need for a judicial independence, how the NJAC is obstructing that. And it is also a retort to the executive wording, especially Mr. Jaitley's word that it is the tyranny of non-elected. He is trying to explain the judicial position. And it is a very well constructed article over here. The first thing is, Indian democracy is built on the bedrock of two things. One is separation of powers and constitutional supremacy. This constitutional supremacy need to be upheld by the judiciary. And separation of powers, though explicitly is not stated in the constitution, it is implicit in the functioning of our entire system. Now in this case, the judicial independence is vital to protect the constitutional supremacy. So, the will of the people as per the separation of powers, it will be reflected by the legislature, and will of the constitution will be reflected by the judiciary. When the will of the people reflected by the legislature and will of the constitution reflected by judiciary, if they come in conflict with each other, then judiciary has to stay with the constitution and protect the values of the constitution. So in this context, a law passed by the parliament and agreed by the 20 plus states need not be declared as unconstitutional is itself is an invalid argument. Because the very purpose of the judicial review is to verify and protect the provisions of a law in alignment with the constitution. So in this context, the criticism of NJAC law is this. It has arrogated the judiciary with more power because of bringing in collegial system back, and it did not respect the legislature and its will. Now in this context, understand the judicial independence. There is a popular statement this way: the judiciary is the lone man or the last man that will be standing between the totalitarianism and protection of the rights of the citizens. In this context, the judicial independence is very critical. So the judicial appointments, they are central to the judicial independence. Now here previously there was an argument. What is that is judicial independence starts after the appointment of the judges. Mukul Rohtagi was talking about. And on the other hand, Mr. Justice Kehar has questioned that judicial independence depends upon the people who are manning the judiciary. So in this context, the appointment of two people, that is from the civil society, to eminent persons and the law minister, it is going to question the judicial independence in two ways, or compromise the judicial independence. One is, in India, government is the major litigant, unlike in many other countries. And second is, whereas important cases involving the executive actions, they come from for judicial hearing. And judiciary has to make a fair judgment on those issues. In this context, the judges appointed, if they enjoy loyalty to the master who is appointing them, then to that extent judicial independence will be compromised. In this context, the primacy of the judiciary in the appointment of the judges of Supreme Court and High Court was established in the case of the second judge's case in 1993 during P.V. Narasimha Rao era. Now the NJAC, it is not just bringing in a transparent mechanism, it is also violating the primacy of judiciary. On the other hand, if NJAC has improved the system and it has retained the judicial primacy in the appointment, probably Supreme Court would have taken the other view. So as a conclusion, we need to understand that democratic values are strengthened by both legislature and judiciary and coordination between both these institutions. So it is not about who is strong. It is about how to build a strong democracy and a partnership for the people to deliver bright justice to them. That is what is the conclusion. Now the second thing is, this article talks about this. The NJAC, it is not about one confronting the other. It is the collaboration between the institutions to achieve the better governance. In that case, what the author argues is this: instead of Supreme Court declaring NJAC as a totally unconstitutional and invalid, whatever the objections raised by Justice Keher, it could have given a solution to them. Probably it could have said that the eminent persons not giving their qualifications is not appropriate and qualifications has to be prescribed. And the second thing, it could have further said that the judges or else eminent persons cannot veto. It is violative of the judicial primacy, which is a part of the basic structure now. In this context, the veto can be transferred to the Chief Justice of India and majority of the judges. So this intermediate path between collegium and NJSC can be tried by the judiciary. Now the author argues that the primacy exists to the judiciary in the appointments, not to the collegium system. It means that the judiciary can give some creative and innovative solutions towards the issue of the appointment of the judges, which can make the process totally transparent and build the democratic values in India. Now it is the beautiful article about the right to privacy, which is directly related to our governance topic. Now, I made this statement which I like to reproduce in my examination. So in 21st century, a government that cannot protect the rights of the citizens, especially right to privacy, it cannot maintain equality among the citizens. So what does this mean? Now, if we see historically, the totalitarian regimes during post-World War II, it have created crisis in Europe. That's why Europe, which has learned from this World War II, most of the countries have shifted to democracy now. The bedrock of the democracy, or else the difference between totalitarian regime and democracy is this. In democracy, the powers of the state are limited. It cannot enter into the sphere or personal sphere of an individual. So, there is a limitation. It is a limited government. It cannot disturb the personal sphere. This personal sphere is protected by an array of rights. That is right to life, right to liberty, and a right to freedom of speech and expression, and a right to vote, right to decide on how to vote. Everything is part of the personal sphere. If this personal sphere has to be properly enjoyed, then right to privacy is very critical. Now in this context, if you see the argument of the government, what the Attorney General Mukul Rohtagi was talking is this. If the people have to enjoy the welfare benefits, the rights are the price which they are paying for that. So, what exactly it means? Here there is something called a doctrine of unconstitutional conditions. The article talks about unconstitutional conditions. What is this doctrine says? In which the constitutional law bars government from imposing a condition on the grant of a benefit requiring the citizen waiver of this constitutional right. It is just like a barter between a constitutional right of a citizen and the benefit the government offers. Such a situation is banned by the constitutional law. It means that the government is suggesting, if a poor man, if he wants to have the benefits of the government, then he has to give his identity to the government. He has to take the Aadhaar. Then, in this context, government is trying to argue a barter system between a right of a poor man and the benefits of the government, which is this violative of the constitution. And the second thing is this, the constitution and the rights under the constitution, they are built on the basis of equality between the citizens. Now, a poor man is made unequal in the enjoyment of his fundamental rights for the exchange of benefit, which will not legally stand. Now here the major challenge is this: how to balance the governance and benefits of governance using the Aadhaar on one side and providing for protection to the rights of the citizens on the other side. Now what is the best way forward? You need to strike a golden mean in between. A golden mean has to come in between to achieve this particular right to privacy over here. So the golden mean is this: you can give access to the government the information, but however security of the information and limited access to the right people in the government, these have to be ensured. Unlimited access which is insecure is ultimately going to create a danger to the right to privacy of a citizen. And next it is about new education policy. In relation to that, he is talking about higher education in India. Now with regard to higher education, we have still the conservative thinking, the traditional bureaucratic thinking. Now, Indian universities, none of them has appeared in the top 200 universities. It means our education policy with regard to higher education, it has to raise to the competition, and the quality need to be improved through innovation. So the conventional thinking will not support that, and out of thinking, box thinking is necessary. In this case, the author criticizes Rashtriya Uchitar Shiksha Abhiyan, so which is meant for improving the gross enrollment rate in the higher educational institutions. It did not think out of box, and now it is thoroughly bureaucratized, and more money is spent on non-creative things rather than improving the quality and access of the education. So the new educational policy has to give a thorough consideration towards innovation and development of education in India. And he also touches the aspects of the foreign universities. The foreign universities, if allowed in India, they can raise the competition and innovation. If India fails to involve the foreign universities in the scope of our policy, then ultimately India is going to fall back, and its dream of institutionalizing the education may be lost. And the next is, with regard to BCCI reform. Now any institution, if the members managing the institution has conflict of interest, members managing that has conflict of interest, it leads to the crisis of the credibility of the institution as a whole. Now, for example, if I am managing the institution and if I try to extract the benefit rather than functioning as an independent neutral person, automatically my credentials will be questioned. So, the conflict of interest has to be removed if one has to raise the credibility. Now let me see. An MP is running a business. Let's take, he is in steel industry. Now this person, if he raises a question in the question hour about the steel policy of the government, here there is clear conflict of interest between him as a representative of the people and also him as the owner of a particular business. So now in this context, his credibility will be questioned. Is it in public interest or private interest? So now if I want to raise the credibility of the IPL, I have to remove the office bearers, etc. from taking up the IPL franchises. And the second thing is, it also suggested about new independent mechanism or independent directors in the governing council. It can bring in fresh thoughts, perspective in governing the BCCI. And also it is initiating an independent agency to examine the funds which were given by BCCI to the state associations, how they are being spent. So it is trying to talk about financial accountability and also the moral accountability by questioning the conflict. And it is trying to provide for independent directors, which it is going to ensure that the process will be well defined without serving the interests of any few people. So here we are ensuring process, and next is the organizational, professional, these three accountabilities we are trying to ensure to bring in a reform in the BCCI. This is what we need to understand. Thank you very much. All the best.